Hello, my name is Alistair Purdy. I'm a partner in Purdy Fitzgerald Solicitors. This is the annual Employment Law Seminar in conjunction with Collins McNicholas Recruitment and Training Group. I'll start on the most topical thing, which is the Temporary Agency Workers Directive. And I think you probably all know what this is about. It's the third in a series of pieces of legislation on atypical employment that has come from the EU. And the first of those was the Part-Time Employees Act in 2001, and that was followed by the Fixed Term Employees Act in 2003, and we now have the Temporary Agency Workers Directive. So taken together, what you're seeing from the EU is a sort of a, for want of a better way of putting it, a squeezing on employers and a push by the EU to try and get employers out of atypical employment and into what I would call more regular, permanent type employment. And what's important about those three pieces of legislation is that they're anti-discrimination pieces of legislation. So in the main, they state that you cannot discriminate against any of those type of workers. And what's interesting actually, aside from that, is you look at those pieces of legislation, in effect, part-timers, fixed-term employees, and perhaps now even agency workers really have more employment rights to some extent than your normal, in inverted commas, full-time employee. So that's an interesting development, I think, over time. So anyway, the Protection of Employees Temporary Agency Work Bill of 2011 was published on the 14th of December 2011. And as you know, we had failed to implement the directive underpinning that bill, which is meant to be in by the 5th of December 2011. And that in itself has given rise to some issues which I'll talk about in a minute. Now, when we were here last year, we were talking about this bill and we were wondering how will it affect on employees, because we didn't have a definition of pay, we didn't have a definition of terms and conditions of employment, and employers in general were very worried as to how that would transpose into Irish law. And I'm glad to report actually it's not as bad, at least I had feared it would be, and I'll go through that in a minute. And it's not as bad for a number of reasons, and primarily the first of those reasons is that the definition of an agency worker is fairly tight in the actual bill itself. And it's very clear that it doesn't apply to independent contractors, doesn't apply to self-employed persons, and service contracts are actually excluded. And that's important because if you are an agency or you're a company utilising agency workers and you have, we'll call it contracted out a large portion of your business, well then the Agency Workers Directive doesn't apply to that. So if you have taken your electrical function, your mechanical engineering function, and you have given it to an outside, they're not technically an agency, but a service provider, they are not agency workers within the meaning of this bill. And I think at least the definition of an agency worker will be transposed into the Act. So that's the first piece of good news on it. Now what it says in general is that agency workers must be treated equally in respect of basic working conditions. And importantly in that regard though, the agency remains the employer of the agency worker. The only exception to that, of course, is for the purpose of the Unfair Dismissals Act, because as you know, an agency worker for the purpose of the Unfair Dismissals Act, the end user is the actual employer for the purpose of that Act. Agency workers must be treated equally in respect of pay and basic working conditions. So what do these include? So it obviously includes pay, it includes working time, rest periods, rest breaks, night work, annual leave, public holidays, and access to information on vacancies in the hiring company, which is obviously there already in terms of the Fixed Term Employees Act, and access to collective facilities such as canteen, childcare facilities, unless there is what is known as objective justification. Now, interestingly, the definition of pay under the bill includes the following: includes basic pay, shift premium, piece rates, overtime, unsocial hours premium, and Sunday premium. So the definition of both basic working conditions and pay is defined as fairly tightly under the Act. And the Minister has indicated that this is an exhaustive list. Therefore, bonus payments, pension schemes, benefit in kind, sick pay schemes are not within the scope of the bill. And this was the big worry in respect of most employers. Would you have to open up your stock option plan your pension scheme, your sick pay scheme from day one to agency worker directive or agency workers already. And actually, that they're actually now, insofar as the bill is concerned, we'll have to wait and see what the Act is, but insofar as the bill is concerned, that's an exhaustive list.